10 years of independence. Our justice system requires an unbiased, neutral judge, someone who will hear all the facts of the case and then decide on it without prejudice, malice, or bias. It is the very essence of the job. There are three concepts that are essential to this goal: judicial independence, integrity, and impartiality. A judge must assume responsibility for the obligation of impartiality. Judges must perceive its need and respond to its call. Judicial independence is a boundary separating the courts from the other elements of government and society, allowing courts to act impartially and maintaining the public's expectation of fairness. In other words, the rule of law. James Madison said that the consolidation of the legislative, executive, and judicial authority would constitute, quote, the very definition of tyranny, unquote. Justice Prosser's campaign has promised, word for word, to build an organization that will return Justice Prosser to the bench, protecting the conservative majority and acting as a common-sense complement to both the new administration and legislature. This doesn't sound like independence from the other bodies of government, and it sure doesn't sound neutral. In fact, it's so far off neutral that Prosser had to recant the statement later. Justice Prosser has repeatedly said that he has, in his words, the most partisan background of the candidates. He served 18 years as a Republican legislator. This is not independent. Secondly, in relation to the concept of independence, the judiciary must be free of outside influence and economic pressures. This frees the courts to decide issues without influence. It is the only way to ensure that we stay a government of laws and not of men. In 1905, another Republican, Teddy Roosevelt, told the Congress, all contributions by corporations to any political committee for any political purpose should be forbidden by law. In 2009, the U.S. Supreme Court decided a case called Caperton versus Massey. They found that judicial campaign contributions violated due process of law. Shortly thereafter, the Wisconsin Realtors and the Wisconsin Manufacturers and Commerce Associations asked our Supreme Court to eliminate restrictions on judges serving in cases when a litigant had made campaign contributions or expenditures for issue advocacy. This means they wanted to be able to have a judge preside over a case where one of the two parties had made substantial expenditures on their campaign, clearly violating the premise of impartiality and independence. Yet, Justice Prosser joined with three others on the court to adopt the rules in the exact language as written by two of the largest corporate campaign contributors. Prosser chided Justice Crook's request for hearings on the rules, calling the request ridiculous. He claims that his campaign committee should be able to solicit campaign contributions from parties with issues before the court. His actions reflect no appreciation of judicial independence or impartiality, but only a concession to power and money. Michael Kirby, an Australian justice, once said, "The alternative to the rule of law is the rule of power, arbitrary, self-interested, and perhaps wholly unrelated to the facts or law of the case." Despite its defects, our adversary system of justice has no equal in the world. At its center is a search for the truth. Witnesses swear to tell the truth. We tell jurors, search for the truth, whatever the truth may be. Integrity requires a commitment to honest objectivity, to determine the truth of the matter. Being able to call a strike when the hometown crowd thinks it's a ball requires integrity. In 1974, Nixon had appointed 4 of the 9 U.S. Supreme Court justices. When confronted with a decision that literally threatened Nixon's presidency, the U.S. Supreme Court decided unanimously that executive privilege didn't protect the president in a criminal investigation. He had to hand over the tapes, and shortly afterward, resigned. Integrity. In his 2008 Supreme Court campaign, Justice Michael Gableman ran a television ad with a photo of his opponent, Justice Louis B. Butler, Jr., next to a photo of Reuben Lee Mitchell, who had raped an 11-year-old girl. The ad read, "Louis Butler worked to put criminals back on the street, like Reuben Lee Mitchell, who raped an 11-year-old girl with learning disabilities. Butler found a loophole. Mitchell went on to molest another child." Louis Butler did defend Mitchell, as was his job as the public defender. But the rapist served his entire sentence and committed his next crime 3 years after his release. News media around the state and nation decried the ad and called for its removal. The Judicial Commission, which enforces ethics rules for Wisconsin judges, said, "The advertisement falsely states that Louis Butler was in some way responsible for the release from prison of Reuben Lee Mitchell and for Mitchell's subsequent crime. It is accomplished by the conflation of 4 sentences into one lie." Prosser joined the majority, stating, "We conclude that the statements in the campaign advertisement were objectively true, and therefore they did not violate SCR 60.063C. In a later discussion, he said, "Besides, the section of the code that regulated Gableman's ad only recommends that candidates not lie about their opponents. It doesn't require them to be truthful." A judge who does not recognize a blatant lie, or who does not care about its impact within the justice system, does not belong on the bench. Period.